There are 51 separate judicial systems in the United States: the state court systems in each of the 50 states, and the federal court system. The federal judiciary is composed of a three-tiered court system. District courts, also known as trial courts, make up the lower level. Circuit courts of appeals are the second level, and the U.S. Supreme Court is the highest court in the federal system. Federal cases begin with a proceeding in a federal district court, and if one of the parties contends that the trial court judge made an error, they can appeal that decision to a federal appeals court. If either of the parties is unhappy with the appellate court's decision, they can ask the Supreme Court to hear the case. The U.S. Supreme Court almost always has the choice whether to hear that appeal. Each state has its own court structure that looks similar to the federal structure. That is no coincidence. When Congress created the federal court structure, it mirrored what already existed in many states. Although all states have trial courts, many have several kinds of trial courts, such as drug courts, juvenile courts, family courts, and others. States typically have mid-level courts of appeals and state high courts, often called the state Supreme Court. For cases involving only state laws, no federal law or U.S. constitutional questions, the state high court is the last stop in the judicial system. There are some circumstances in which the U.S. Supreme Court can hear a case beginning in the state court system. For example, sometimes cases involve both state and federal legal questions. Those cases can begin in either of the federal or state court systems. If a case begins in the state court system, the U.S. Supreme Court could review the state court's interpretation of the federal question, or if a party contends that a state law violates the U.S. Constitution, the U.S. Supreme Court has the power to review the state Supreme Court's decision. In addition to hearing cases appealed from lower federal or state courts, the U.S. Supreme Court also hears cases through its original jurisdiction, meaning its power to hear certain cases as a trial court. There are not many cases, as they most commonly involve a lawsuit between two states, because the framers were afraid the lower courts would favor one state or the other. They gave the U.S. Supreme Court alone the power to decide these cases. The U.S. Supreme Court must hear the cases coming to it under original jurisdiction, but it has the power to decide which of the appellate cases it hears. Out of the 8,000 to 9,000 cases appealed to the Supreme Court every year, it typically hears 80 to 90 and rejects the rest. If the court rejects an appeal, the lower court's decision stands.